ago during our hearing on the nomination of Judge Sotomayor to the Supreme Court. Though not perfect and no hearing is, the hearing did provide us a chance to ask questions and also to raise concerns. It gave the nominee an opportunity to respond to relentless critics having had to remain silent for the 2 months prior to the hearing. It's finally her chance to have a public voice. And allowed the American people, most importantly, to see and hear Judge Sotomayor for themselves. It's interesting, during those 4 days, almost 2,000 people attended the hearing in person in this room. Millions more saw it or heard it, read about it, thanks to newspapers, blogs, television, cable, and of course, in the Judiciary Committee, we have webcasting. I believe that President Obama is right when he told the American people last May that Judge Sotomayor will bring not only the experience acquired over the course of a brilliant legal career, but the wisdom accumulated over the course of an extraordinary journey. A journey defined by hard work, fierce intelligence, and enduring faith that in America, all things are possible. So I thank Judge Sotomayor and her family for participating in our hearing with such intelligence and grace, and I might say, and patience. Now comes with the moment when this committee is faced with the choice of whether to recommend this nomination favorably to the Senate. Each of us, as senators, has a responsibility to vote yes or no. I look forward to a bipartisan vote. Judge Sotomayor is well qualified. She has the highest rating in the American Bar Association. And one need look no further than her experience, her ability, her temperament, her judgment. The President nominated a person with more federal judicial experience than anyone nominated to the U.S. Supreme Court in nearly 100 years. He nominated somebody with federal trial judge experience. She'll be, incidentally, the only member of the Supreme Court with federal trial judge experience. And, of course, she had tremendous experience in probably the most active prosecutor's office in this country. As her record and her testimony for the committee reinforced, she's a restrained, fair, and impartial judge who applies the law to the facts to decide cases. Ironically, the few decisions for which he's been criticized are cases in which he did not reach out to change the law or defy judicial precedent. In other words, cases in which he refused to be an activist judge and make law from the bench. In her 17 years on the bench, there's not one example, let alone a pattern, of her ruling based on bias or prejudice or sympathy. She's been true to her oath. She's faithfully and impartially performed her duties as set forth by the Constitution. As a prosecutor and as a judge, she has administered justice without favoring one group of persons over another. She testified directly to this point, saying, "I have now served as an appellate judge for over a decade, deciding a wide range of constitutional, statutory, and other legal questions. Throughout my 17 years on the bench, I have witnessed the consequences of my decisions. Those decisions have not been made to serve the interests of any one litigant, but always to serve the larger interests of impartial justice." I agree with her. During my time in the Senate, I've often spoken of the standard that I use for judicial nominees. I asked myself whether the nominee be the kind of independent judge who would be fair and impartial. As one who's tried an awful lot of cases, I look at a judge and I say whether any American could expect fair consideration of this judge, regardless of race, whether they're rich or poor, whether they're a person, a corporation, defendant, or the government, whether Republican or Democrat or independent. I like to think that when I would come into a courtroom, I could look at a judge and say, This judge will make up his or her mind based on the law, not on who the litigants are. And having reviewed her record, I know that Judge Sonia Sotomayor has been that kind of judge. I'm very confident she'll be that kind of justice in the United States Supreme Court. And so it's with enthusiasm and hope that I'm going to vote in favor of this historic nomination. And we'll recognize first time with Senator Sessions, and then we'll go back and forth based on seniority. Is that okay with you?
Thank you. Yes, Mr. Chairman, you're very gracious, and you conducted a fair hearing. And I don't know if that's on or not, but you conducted a fair hearing, and for that we're appreciative. I think our people, a little 7 on our side against this 12 on your side, had a duty and a responsibility to ask the questions that are pertinent to this nomination. I believe they were done so effectively and thoroughly and fairly. I really appreciated the grace that Judge Sotomayor showed. She was patient, as you said, and she took care to participate in the process and in a way that I think reflected well on her personally. I would just say, Mr. Chairman, that as I explained on the floor yesterday, based on her record as a judge and her statements, I am not able to support this nomination. I don't believe anyone should be on any court of the United States that is not deeply committed to the ideal of American justice, and that is that they should set aside their personal opinions and biases when they rule from the court. But in speech after speech, year after year, Judge Sotomayor set forth a fully formed, I believe, judicial philosophy that conflicts with the great American tradition of blind justice and fidelity to the law as written. Her words and speeches are not being taken out of context, as some have suggested. She has repeatedly said, among other things, that judges must judge when, quote, opinions, sympathies, and prejudices are appropriate, close quote. She accepts that who she is will, quote, affect the facts I choose to see as a judge. It is her belief that, quote, a wise Latina woman with the richness of her experiences would more often than not reach a better conclusion than a white male, close quote. And that there is, quote, no neutrality in judging, just a, quote, series of perspectives. Well, those are phrases and words that have meaning. I will agree that her testimony was not consistent with those repeated phrases and statements, but I have to say her testimony to me did not have the clarity and the compelling nature that would overcome those speeches. But, for example, on the question, she testified when I first asked her that she was agreeing with Justice O'Connor, but in fact, her statement, and when Judge O'Connor said a wise old woman and a wise old man should reach the same conclusion, which is, I think, the ideal of American justice, in her speech, she said, quote, I am not sure I agree with that statement, and went on to explain why she didn't and what her reservations were. So we were urged to look at the judicial record that she has established, and I've done that. Most cases before the courts of appeals are fact-based, do not raise serious constitutional issues of the kind that the Supreme Court deals with on a regular basis. Judge Sotomayor decided 3 cases in recent months, in particular, that are of the type that the U.S. Supreme Court hears on a regular basis. The decisions are extremely short, oddly short, frankly, and lacked careful analysis. Each reached, I think, an erroneous conclusion. Each ignored the plain words of the Constitution. In Ritchie versus DeStefano, which came to her 3-judge panel for the Second Circuit, it was an appeal by 18 firefighters. The test that they took to pass for promotion had been thrown out by the city, not because it was an unfair test. Indeed, it was never found to be unfair, but because the city did not like the racial results. Her opinion violated the constitutional command, I believe, that no one should be denied the equal protection of the laws because of their race. Judge Sotomayor did not deal with this important constitutional issue in a thorough, open, and honest way. Without justification, in my view, and in violation of the rules of the Second Circuit, they initially dismissed the case by summary order, without even adopting a lower court opinion, with no explanation whatsoever. The effect was to deal with it in a way that would not require the opinion to be published or even circulated among the other judges on the circuit. The circuit rule states that when summary orders are appropriate only where, quote, a decision is unanimous and each judge on the panel believes that no jurisprudential purpose would be served by an opinion, close quote. So it was only after another judge on the circuit requested that the case be reheard that the panel issued a per curiam opinion, and of the briefest nature, only a few sentences, that adopting the lower court opinion. So I didn't feel good about that. That was a big case, a huge case of great importance. If not, the Supreme Court wouldn't have taken it, and they were trying to dispose of it by summary order. Judge Sotomayor's treatment of critically important Second Amendment issues that have come before her are equally troubling. Again, I think she got the text of the Constitution wrong, and did so in a cursory way that seemed designed to hide the significance of the case and her ruling. In Maloney, even after the watershed decision by the Supreme Court in Heller, she held that it was settled law, that the Second Amendment did not apply to the states, and that the right to keep and bear arms is not, quote, a fundamental right. When asked about the Maloney case at the hearing, she claimed to have relied on precedent, but the precedent on which she relied considered the Privileges and Immunities Clause of the 14th Amendment. And the Supreme Court has not really looked at that clause for over 100 years. Instead, it's looked at the Due Process Clause under the Bill of Rights. And the law has changed how we do incorporation since the 1800s. And I think for her to fail to acknowledge that, and to fail to acknowledge the very clear suggestion in the Heller case, in that famous footnote, that this matter is now open for consideration. Again, it's not settled law. In fact, the Ninth Circuit, reviewing the Supreme Court decision in Heller, reached a different conclusion altogether, that the Second Amendment does apply to the states based on the Supreme Court opinion. And I think that was a big error. And would note that if her decision is not overruled by the Supreme Court, on which she aspires to sit, then any city and any state in America could completely deny the right provided in the Constitution to keep and bear arms. And they could deny the right of people in their cities and their states to keep and bear arms. And a third case handled in a similar cursory manner, and the Maloney case was, what, 2 pages, a page, maybe less than 2 pages, was the important property rights case. 3 years ago, the Supreme Court in Kelo decided, 3 years ago after Kelo, after the Supreme Court decided the Kelo case, Judge Sotomayor's court issued an opinion in which a private property owner found his property, on which he planned to build a CVS pharmacy, taken by condemnation by the city so that another private developer could build a Walgreens pharmacy on it. And the developer, who was pursuing a redevelopment supported by the city, told the landowner he could keep the land and build that CVS as long as he forked over $800,000 to him and half ownership of his business. So in another 2-page opinion, short, without much discussion, she rejected those claims. And the Constitution says private property can only be taken for public use. And that was not followed in that case. So each of these 3 cases of importance, deserved to be treated with great thoughtfulness and care. Yet in each instance, her decisions were unacceptably short, and their only consistency was that the result favored a liberal pro-government ideology against the individuals asserting their constitutional rights. And so, Mr. Chairman, I appreciate you, and I know people will disagree on this and can disagree honestly, but after all is said and done, my evaluation of the testimony at the hearing and the study of the cases I've mentioned, I've concluded that this nominee should not be confirmed and will cast a no vote.
Thank you, Senator. Senator Cole.
Thank you very much, Mr. Chairman. I want to congratulate Chairman Leahy and Senator Sessions, as well as your staffs, on Judge Sotomayor's confirmation hearings. The proceedings are fair to all members and, most importantly, to the nominee. Today, I am pleased to cast my vote for Judge Sotomayor, an individual whose life story is an inspiration to millions of Americans. A child of immigrants with modest means, Judge Sotomayor has risen by dint of exemplary academic accomplishment and hard work, now to the cusp of confirmation to our nation's highest court. But Judge Sotomayor is much more than only a story of accomplishment. She has shown herself to be a judge truly worthy of elevation to the Supreme Court. Both on the bench and before this committee, Judge Sotomayor has proved that she has the necessary character, competence, and integrity to serve on the Supreme Court. Judge Sotomayor's distinguished 17-year judicial record demonstrates her commitment to fair and impartial application of the law and respect for the values which make up our Constitution. At her hearing, Judge Sotomayor assured us that she will listen with an open mind to all sides of an argument and that she will be mindful of the very real impact her decisions will have on each and every American. She pledged fidelity to the Constitution and to the Court's precedent, as well as a responsibility to cautiously review precedent when justice requires. As we conclude our committee's action on Judge Sotomayor's nomination, I believe we need to reflect upon the role that confirmation hearings play in the Senate's duty to advise and consent. While I have no reservations about my support for Judge Sotomayor, I share the concerns expressed by many Americans, legal commentators, and others about our committee's ability to have candid and substantive conversations with nominees about the issues Americans care about. We all know that the confirmation process is crucial. It is the public's only opportunity to learn about a nominee before he or she serves for life on the highest court in the land. But for many years, we have seen a familiar pattern from nominees, Democrat and Republican alike, who have learned that the path of least resistance is to limit their responses and cautiously cloak them in generalities. Understandably, nominees don't want to risk their confirmation by saying anything that might provoke potential opponents. And we cannot ask nominees to disclose how they would vote on cases that might come before them. But it is reasonable for us to ask them to speak more openly about past Supreme Court decisions and how they would decide cases that are close calls, what reasoning they would use, and what factors they would consider. The concerns I raised do not reflect any personal criticism about Judge Sotomayor. I think she responded to our questions with great intellect and sincerity, and that she has rightly earned bipartisan praise. However, going forward, Mr. Chairman, I hope that together our committee can explore ways to achieve the greater candor that the confirmation process demands and that the American people deserve. For example, we could convene a bipartisan group of committee members, members of the bar, constitutional scholars, and perhaps members of the media who have experience following the court and our hearings to help us determine what specific questions we can and should expect substantive answers about. If we can do this, then the committee's unique opportunity to engage nominees in the great legal questions facing our nation will more effectively fulfill the Senate's constitutional duty. In the meantime, I commend President Obama for nominating Judge Sotomayor, a woman of great ability who has demonstrated an enduring commitment to public service and to the law. I look forward to her tenure on the court. Thank you.
Thank you very much, Senator Cole and Senator Hatch.
Well, thank you, Mr. Chairman. I want to commend you and the distinguished ranking member, Senator Sessions, for conducting a fair and thorough hearing on the nomination of Judge Sonia Sotomayor to replace Justice David Souter. I was especially pleased when Judge Sotomayor said the hearing was as gracious and fair as she could have asked for. I came to the confirmation process wanting to vote for a president's nominees, and the prospect of a woman of Puerto Rican heritage serving on the Supreme Court says a lot about our country, America. I like Judge Sotomayor and respect her service to her community, the judiciary, and the nation. And as I expect her to be confirmed, I know that her service will continue for years to come. I spent a great deal of time reading Judge Sotomayor's speeches, articles, and cases, and I participated in all 3 rounds of questions at the hearing. I genuinely wrestled with this decision. I did not use the political standard taken by Senator Barack Obama in 2005 when he voted against Chief Justice John Roberts. He voted no, even though admitting that the nominee was qualified, humble, decent, and had the temperament to be a good judge. Senator Obama voted against Chief Justice Roberts because he thought the nominee's personal values, perspectives, and empathy would lead him to results that Senator Obama would not like. Now, I cannot accept that standard. I believe the proper judicial role in our system of government focuses on the process of interpreting and applying law that leads to results, not on results themselves. And I believe that in the judicial process, judges must self-consciously and deliberately set aside personal views, sympathies, and prejudices so that the law, not the judge, determines the results. I have a statement, Mr. Chairman, which explains in more detail the decision I've reached in this case, and I ask consent that it be placed in the record.
Without objection, it will be placed in the record, and of course the record will be open for any member who wishes to extend whatever they say.
Thank you, Senator. Now, let me just say here that I examined Judge Sotomayor's entire record with the more exacting scrutiny appropriate for Supreme Court nominations. Her speeches and articles evidenced and described a troubling approach to judging that her hearing testimony did not resolve, as far as I was concerned. In some of her most important cases, she gave short thrift to fundamental constitutional rights, and in my judgment used inappropriate legal standards and did not properly apply precedent. In the end, Judge Sotomayor's record regarding her approach to judging simply left too many unresolved controversies and too many conflicts with fundamental principles about the judiciary in which I deeply believe. As a result, I regret I cannot support her appointment to the Supreme Court, and my extended statement will go into this in much more detail. Thank you, Mr. Chairman.
Thank you very much, Senator, and Senator Feinstein.
Thank you very much, Mr. Chairman, and thank you for conducting these hearings in the way in which they were held. It's very much appreciated. Mr. Chairman, it's interesting to me to hear the comments of those who clearly will not vote for this judge. For me, I look at her very differently. I see her as a most impressive person on a number of different levels. First, in terms of personal history, it is truly impressive. It is everything that our country is all about. Secondly, in terms of qualifications, there are more qualifications for this job than virtually any of the prior 3 nominees that I have heard as a member of this committee. 29 and a half years in the law, prosecutor, private practitioner, appointed to the federal court first by a Republican president, secondly by a Democratic president. And the analysis of her record by the Congressional Research Service says a very interesting thing. The most consistent characteristic of her approach as an appellate judge has been an adherence to the doctrine of stare decisis, precedent. I think this woman has done a splendid job. She has shown a dedication to the law. This has been tested and tested. She has shown before us judicial temperament. This has been probed and picked at. I find no example of infidelity to the law. At this point, Mr. Chairman, if I might, I would like to place in the record a Sixth Circuit Court decision on a Ricci case-like matter where the Sixth Circuit found exactly as she did, if I might.
Without objection, so ordered.
Thank you. I found no example of her not following precedent. For me, as a woman, to see this woman overcome the barriers that she has overcome, to have the education that she has had, to do with it what she has done, and to bring the kind of dedication and personality to this table was truly impressive. I believe she has been an impressive judge. I believe she's been an impressive lawyer, and I believe she will be an impressive member of the highest court of this land. I will vote for her with enormous pride. Thank you, Mr. Chairman.
Thank you very much, Senator Feinstein and Senator Grassley.
Thank you, Mr. Chairman. After much deliberation, I've concluded that I cannot support the nomination of Judge Sotomayor to be Associate Justice. The Senate must confirm to the Supreme Court individuals who possess a superior intellect, distinguished legal experience, unquestioned integrity, and even judicial demeanor and temperament. More importantly, the Senate has a tremendous responsibility to confirm individuals who truly understand the proper role of justice as envisioned in the Constitution. This is the most critical qualification of a Supreme Court justice, the capacity to faithfully interpret the law and Constitution without personal bias or prejudice. Our system of checks and balances demands that judges not take on the role of policymakers. That's because our great American tradition of checks and balances envisions that political and social battles be fought in the legislature, not the judicial branch of government. Further, our American legal system requires that judges check their biases, personal preferences, and politics at the door of the courthouse. Just as Lady Justice stands before the Supreme Court blindfolded, judges and justices must wear blindfolds when they interpret the Constitution and administer justice. I've been a member of the Senate Judiciary Committee since 1981 and have voted to confirm both Republican and Democrat presidents' picks for the Supreme Court using this standard. Unfortunately, I believe that Judge Sotomayor's performance at her Judiciary Committee confirmation hearing left me with more questions than answers. It is imperative that the nominee persuade us that he or she will be able to set aside one's own feelings so he or she can dispassionately administer equal justice. Yet, I am not convinced that Judge Sotomayor has the ability to wear the judicial blindfold and resist having personal biases and preferences dictate her judicial method on the Supreme Court. President Obama clearly believes Judge Sotomayor measures up to his empathy standard, which encourages judges to make use of personal politics, feelings, and preferences. This radical empathy standard stands in stark opposition to what most of us understand to be the role of the judiciary. To her credit, at the hearing, Judge Sotomayor repudiated President Obama's empathy standard, but Sotomayor's record, both in and out of the courtroom, revealed to me a judicial philosophy that bestows a pivotal role to personal preference and beliefs in her judicial method. In speeches she gave and law review articles she wrote over the years, Judge Sotomayor doubted that a judge could ever be truly impartial. She argued that it would be, quote, a disservice both to the law and to society, unquote, for judges to disregard personal views shaped by one's, quote, differences as women are men of color, end of quote. She proclaimed that the Court of Appeals is where, quote, unquote, policy is made. She said that a wise, quote, a wise Latina would more often than not reach a better conclusion than a white male, end of quote, and disagreed with a statement by Justice O'Connor where Justice O'Connor said, quote, "A wise old woman or a wise old man would eventually reach the same conclusion in a case," end of quote. She said that judges should look to foreign law so that they can get, quote unquote, creative juices flowing. At her confirmation hearing, Judge Sotomayor attempted to explain these statements away. However, I had problems harmonizing her answers with the statements that she repeated over and over again throughout the years. The statements made at the hearing and those made in speeches and law review articles outside the hearing are, in my mind, polar opposites of each other. They're not compatible and cannot be reconciled. I also question the reliability of statements made at a formal hearing where the nominee is clearly prepared to answer questions as compared to statements that were made over the years in any unguarded manner without any restrictions and without a set goal in mind, that being confirmation to the judicial branch. In addition, Judge Sotomayor's record on the bench raises serious concerns. Hard questions, her hard cases say the most about a judge. And we all know the Supreme Court takes on only hard cases. Well, those are the cases that raise the most concern with this nominee and what she will do if she is confirmed. First, her record before the Supreme Court is not a particularly impressive one. She was reversed 8 out of 10 times and was criticized another one of those 10 cases. So the Supreme Court disagreed with her 9 out of 10 times. In addition, some of her cases raise questions about whether she will adequately protect the Second Amendment's right to bear arms and the Fifth Amendment property rights. Statements she made at the hearing raise concerns that she will inappropriately create or expand rights under the Constitution. Further, some of her cases raise questions about whether she will impose her personal policy decisions instead of those of the legislative branch or executive branch. At her confirmation hearings, Judge Sotomayor was questioned at length about her understanding of rights under the Constitution, including the Second and Fifth Amendments and the right to privacy, and raised and the rationale for her decisions in Rishi, Maloney, and Didden, and other cases. She was also asked about how she views precedent and how she applies it in cases before her. Unfortunately, I wasn't satisfied Judge Sotomayor's responses about her cases or her general understanding of rights under the U.S. Constitution. Moreover, I wasn't assured of Judge Sotomayor would disregard her strong personal sympathies and prejudices when ruling on hard cases dealing with the important constitutional issues. For example, I wasn't persuaded by Judge Sotomayor's claim that she followed precedent in Rishi, nor her explanation as to why she could dismiss such a significant case with absolutely no legal analysis. I was concerned with Judge Sotomayor's explanation of her decision in Maloney, holding that the Second Amendment is not fundamental, and her refusal at the hearing to affirm the Americans have a right of self-defense. If Maloney is upheld by the Supreme Court, the Second Amendment will not apply against state and local governments, thus permitting potentially unrestricted limitations on this important constitutional right. I was troubled with Judge Sotomayor's failure to understand that her decision in Didden dramatically and inappropriately expands the ability of state, local, and federal governments to seize private property, and she mischaracterized the Supreme Court's holding in Kelo. Judge Sotomayor's discussion of landmark Supreme Court cases and her own decision on the Second Circuit did not convince me that she understands the rights given to Americans under the Constitution, or will refrain from expanding or restricting those rights based upon personal preferences. Nor was I persuaded that the judge will not allow those personal beliefs or preferences to steer her judicial methods and outcomes of cases. At her confirmation hearing almost 2 decades ago, then Judge Souter, or at his confirmation hearing, I want to refer to Judge Souter. Speaking about